sauntered a few minutes. We hope we're not wearing you out. You look a little tired.
Well, thank you. Thank you.
Appreciate you
Chair.
coming to present, let's see, House Bill 368 Elector Amendments.
Thank you very much. I do appreciate your patience. It's one of these things where I was presenting 4 bills in 3 committees, but meeting from 4 to 6. So anyway, HB 368 is just something that a constituent actually came to me and suggested. He said, we don't have any bill in Utah or any law in Utah that makes any provision for dealing with faithless electors. I went, faithless electors? My good friend, Representative Chavez Howe, undoubtedly knows that off the top of her head because she's up on election law, but I didn't. I said, what do you mean? He said, when we have individuals that are chosen to act as electors in national presidential elections, they have to cast their votes in a certain way, but his concern was that occasionally you will have electors tempted or induced or attempted to be induced to cast their votes in a way that is different from what the state has voted, basically. In the last election, somebody comes along and requests that one of the Utah electors cast their vote for somebody other than Mitt Romney, for example. That is something that has happened, not frequently, but it has happened occasionally in past elections. So I took a look at that section of our code, and that section of the code was surprisingly unclear. I talked to our Ledge Research and General Counsel about it, and they said, well, there's actually very little that specifically talks about how electors are required to cast their votes. So what you see in the bill is on page, over here on page 4, lines 110 through 113 just makes clear that the elector is required to cast their vote for the candidate for president or vice president who wins the majority vote of the state. So in other words, electors in Utah are required to cast their vote for the candidate, the presidential and vice presidential candidate who win the majority vote in Utah. And if they don't, they're guilty of a third-degree felony. So that's basically the bill in its simplicity. It's designed to keep our electors honest.
Okay, the chair has a question. Felony, that's pretty hefty fine, or pretty hefty charge.
CCJJ came to me and said, we don't know we like that. How about a Class A or Class B misdemeanor? I'd be happy to have someone, if they choose to, on the committee make that amendment. That doesn't trouble me to have it be something other than third-degree felony. I thought it needed to be something that was other than an infraction.
Sure.
But a misdemeanor doesn't trouble me to any degree.
Does that conclude your presentation, Representative?
Well, the only other thing that I would note is that there's no fiscal note attached to it.
Okay. Clarifying questions from the committee. Representative Mathis.
Can I have the attorney in the room somewhere tell me the difference between the Class A, Class B misdemeanor, and third-degree felony?
Art, we're having Mr. Hunsaker check for us. It's obviously a question of potential fine and jail time. I'm not sure of I know what it is for a Class A misdemeanor. It is up to a year in jail and up to a $2,500 fine for a Class A misdemeanor. But I'm not sure what it is for a third-degree felony.
My understanding, and I asked J.C. Skinner about this at CCJJ about it, I said, well, my understanding, J.C., is that if you're convicted of a felony or if you're subject to a felony, you risk spending more than a year in prison, and you risk spending it at the state prison system as opposed to a county jail. And she said that's right. So misdemeanors are a year or less, or maybe less than a year, and felonies have the potential imprisonment for more than that. And you're right, there is, well, I've got that information here. My faithful intern has.
Okay.
A Class A misdemeanor is punishable by no more than 1 year imprisonment in a county jail and a fine of up to $2,500. In addition, there may be victim restitution. Class B misdemeanor is punishable by no more than 6 months imprisonment in a county jail and a fine of up to $1,000 in addition to victim restitution. Class C misdemeanor is punishable by no more than 90 days in the county jail and a fine of up to $750. Felonies, of course, are at higher.
Do we
time
have
and amount.
what a third-degree felony
Yeah,
would be?
third-degree felony is 0 to 5 years in prison and up to $5,000 as the possible fine.
Is there any appetite on the committee for an amendment? I believe as chair I would propose, if that's in order for me to propose an amendment? Is that in order?
I would think so.
I think I would propose that we, on line 117, that we strike third-degree felony and replace it with a Class A misdemeanor. Seems to me that a felony that has an effect for the rest of a person's life. A Class A does too, but not nearly as significant. And I'd enjoy the response of the sponsor on
Perfectly fine, Representative. I don't have a problem with that at all.
Okay, it's moved that we amend line 117 then and strike third-degree felony and replace it with Class A misdemeanor. Any discussion to that motion? All in favor of the amendment, please say aye. Aye. Are there any opposed? Say nay. So the bill is amended, and we would be happy to hear any public comment. I see no more questions from the committee. Yes, come forward, please. If you could state your name and sign the roster, please.
I'm Cheryl Eaker, and I have a question, and perhaps Representative Ivory can help with this too, because I consider you to be a pretty good constitutional scholar. I'd like to ask about where this is again in our Constitution and what the position is of the state constitution on the elector at this point. Does anyone know that?
Representative Ivory or Mr. Hunsaker, either one have a thought on that?
I'm not familiar enough with the
I'm sorry, I don't.
Constitution
Yeah,
says.
I don't know.
Okay.
I have to tell you, and for Ms. Eager too, I was surprised at the lack of specificity or identification of what an elector is required to do. They came back to me with this draft and they said, well, you can put a penalty in there if you want, but quite honestly, it's very unclear what the elector is required to do at all. And I said, well, let's put that in there too then.
Interesting.
So, I don't know.
Yeah, I've just, I found in my study of this whole issue on a broader scale that you're absolutely right. There is a lot of vagary about what it means. And so I would like to recommend that the committee investigate that piece before we move forward to create a law that might not be commensurate with our state constitution. And just briefly, some historical background, as you may well know, when the founders created the Constitution, they set up actually a balance of powers in the way we elect. The president was elected by electors from each state, which comprised the federal delegation, and that number of votes would go to Congress, and if there was a tie, of course, the House would break that tie. But then the 12th Amendment changed that. But the point being, at that point in time, those electors were free agents. And so I'm curious to know how that was interpreted by our Constitution, where that stands today before we make this change. Of course, after the 12th Amendment, the presidential election became a popular vote. And then, of course, the Senate also became a popular vote when it was meant to be the state legislature, which I would love to see happen at some point again so that you guys could have a little bit more say and what happens on the federal level. But that's really the comment that I just wanted to make, and to ask you to exercise some caution before making a final decision on this in this hearing today, and to check out what the Constitution says.
Thank you, Ms. Eager. Is your question, Representative Chavez-Houck, for the witness?
It's less of a question and more just a follow-up on a question for the sponsor related to that, and some information that I have also. Representative, do you have an idea of other states and how many other states have already implemented a requirement / and penalty for not responding to the will of the people in an elector casting their vote? And then has that been challenged by any court, or is there a case law that says that that should not happen?
I don't have the precise figures for you, Representative, on that, but I do know that many other states have provisions that provide criminal penalties when you have, boy, you are just on top of this one. Y'all ought to have an intern that's as good as mine. Huh?
Terrific.
There are, it looks like, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Looks like 32 states that require electors to vote as pledged or as required by their state statutes. So most states do something to attempt to bind electors to vote in the way that they're pledged to vote or that the statute requires.
Yes, I'm just looking at the provision in Article 2 in the Constitution, the U.S. Constitution, that relates to electors, and why it doesn't go into detail as to binding the elector. There is a lot that relates to explaining to that person the severity with which their trust has been given from the members of the citizens in the state and the voters in the state. And given the fact that other states have moved forward with this, that it hasn't been challenged to any extent that we know, again, I think that's just a role that is being held with confidence on behalf of the electorate, and we should add some strings to that and some strength to it. So anyway, thank you. Thanks for the input.
Representative Ivory?
Yeah, to the sponsor, I've been kind of struggling with how to sort out the language and what the impact may be, and the unforeseen impacts on something of this magnitude. Do you, Representative, know what the specific language is in those other 32 states? Is it this language, or is it something else?
No, I don't think it's this language. I mean, this is just language that I came up with in working with the bill drafter to reflect what I thought was clearly the only way that you could have our electors bound to vote, which is, I don't care who wins the election, in the presidential and vice presidential ticket that gets the most votes in Utah ought to be the ticket that gets the electors' votes when the Electoral College meets. And that was the only thing I was trying to accomplish. So the answer to your question, Representative Ivory, is I don't know what the other states have.
Representative Powell?
I really apologize that I had to attend to another issue quickly, and I've heard most of the discussion, but I just want to make sure I ask Representative King, why is the language that's currently on lines 110 and 111 not sufficient? Why do we need to change? It says any elector, the current statute says any elector who casts an electoral ballot for a person not nominated by the party of which he is an elector. What's the sponsor's motive in changing that?
Well, I think it's a little less than as... There are two things that I was hoping to accomplish here. Number one, the first thing is impose some penalty. And you see that on line 117. We've changed it. I don't know if you're here when the amendment...
Yeah, I see that.
So the amendment was passed to make it a Class A misdemeanor. That's the primary purpose, is to impose a penalty for a faithless elector. I think that you're right in saying 110 through 112 say in a less clear fashion that the obligation of the elector is to cast the ballot for who gets the majority vote in Utah. Because, but it sort of presumes that you understand that each party nominates a slate of electors, and that it's less straightforward than I would like
Yeah, well,
to see.
nobody understands this statute. I remember doing a paper on the Electoral College in undergraduate, and I didn't understand until I got to graduate school what the Electoral College really, really does. So I don't know that we're going to make that any clearer. And then let me ask a follow-up question back on the first question that you just raised. If you and I know very well that this statute operates to basically kick that elector out of their office if they become a faithless elector under Utah statutes, why do we need a criminal penalty?
Because I think that's a good question, because it does. The statute already says that they shall have been to have considered resigned. I want to put in place a deterrent. I want to put in place something straight up from the get-go that electors know, look, this is more than just behaving badly. This is more than if you are faithless, you'll be considered to have resigned. I think that it's important that we maintain the integrity of the system in a way that is a little more direct. And one of the ways that we can maintain the integrity, or likely maintain the integrity and the faithfulness of the elector, is to say up front to them, if you do something other than what you're required to do, it's a crime. I like that directness of that.
Representative Noel.
I guess I got the same kind of questioning, Mr. Chairman, that the representative from Wasatch County has, and I guess I just don't see, how many times has this happened, would be my question, that electors have not followed through on voting for the individual that got the most votes in the state, and let's just say in the past 40 years, how many times has this happened?
I don't think it's ever happened in Utah, not that I'm aware of. It's happened across the country, couple handfuls of times.
Sounds like everybody's acting responsibly without us making laws.
Okay.
Anyway, that's all I've got.
Thank you. Representative Ivory, did you have a...
No, that was my question.
Okay.
Exact same question.
Seeing no further questions from the committee, are there public comment beyond what we've received from Ms. Eager? Thank you.
When I said that the presidential form of election was a popular vote, I do recognize there is an electoral college also
Okay.
accompanying that. That's what we're talking about.
Thank you. As chair, I'd like to ask Mr. Thomas if you'd please come forward and help us with this. There appears to be a question on the committee regarding the need or the appropriateness of a law such as this in terms of classifying it as a Class A misdemeanor with its accompanying punishment and so on. Could you address that for us?
To the best I can. Sorry, I just walked in and I didn't listen to the whole presentation. I've been involved myself in two of the presidential electors over the last couple of presidential cycles, and in each of those times they've gone smoothly. We haven't had any issues. There was a small group out there who were this last election trying to persuade at least a couple of the electors to maybe vote for another candidate who didn't win the election based upon what they thought was some fraud in the elections in other states. And so we were prepared to handle that should that happen, but nothing did happen. So I don't have much more beyond that unless you have a specific question.
Thank you. That does help. Any other public comment? Seeing none, we'll return to the committee for potential action. Representative Ivory?
Thank you, Mr. Chair. Yeah, I would like to make a motion that we send this back to rules that they consider whether or not to put this on an interim study.
That's a motion to return the bill to rules. Discussion to the motion. Representative Chavez-Houck?
I'd like to speak to that too, if I may.
Oh, okay. First, please do that.
Yeah, I'm not positive that we've got enough information in other states and what the language is and where this goes and what the impacts may be, and in consideration of the good representative bringing this forward, I think maybe we ought to look at it and see what other information we might need.
Representative Chavez Hauk.
Thank you, Mr. Chair. I'd like to make a substitute motion.
That would be in order.
Thank you very much. I'd like to make the motion that we move out HB 368 as amended with the favorable recommendation. I'd like to speak to that, please.
Okay.
Yes, I think that the fact that we have precedents in other states of having implemented something and put something in code related to telling electors that they are being given a position of trust that is paramount and that shouldn't be taken lightly. Just so that you have some context, yes, it is rare, but in the history of the American Electoral College, as of 2008, 156 faithless electors have been recorded. Now, notably, about 71 of those were forced to become faithless because of their pledged candidates died. But there are others who have exercised a right of conscious objectors and have voted against the will of the people. Now, notably, yes, they would be forever not allowed to serve in that position again. But I think putting a criminal penalty helps them understand, helps the people know that they can have some faith and confidence in those electors, knowing that they are being placed in trust on their behalf. So anyway, I would like to make a motion that we pass it out favorably.
The substitute motion is to pass out House Bill 368 as amended, Elector Amendments, with a favorable recommendation. Discussion to that motion. Seeing none, we'll go to the sponsor for summation. Excuse me, Representative Powell, did you have a comment?
No, I know we want to get out of here. I just quickly explain my vote. At the current time, in all deference to my colleague, I personally don't see the need to pass either of the policy considerations in this bill, either the criminalization or the changing of the language to vote for the majority candidate. So I do think it's an issue that should be studied further, and I won't be supporting the substitute motion. Thanks.
Other discussion? To the sponsor for summation then. Well, let's see. We need to, no, that'll be, yeah, we'll go to summation from the sponsor. Thank you.
Well, I appreciate the substitute motion. I think that this is a relatively straightforward change. I think that it's important to send messages to the electors that this is an incredibly serious responsibility that they have. They should not be considering changing their vote. Right now, there's nothing other than automatic disqualification, which is no penalty at all if they want to make a statement, if they want to send a message that they support some person that they think for whatever reason is the ideal presidential candidate or vice presidential candidate. They can make that statement, get a lot of press, and walk away with impunity. So I think there needs to be, at the very least, a criminal penalty, even if it is accurate to say that the statute in other respects in terms of the obligation to vote is clear. There certainly needs to be a criminal penalty there.
Thank you, Representative King. Back to Representative Chavez Hauk for summation.
Waive.
Summation is waived. All in favor of the motion to pass out House Bill 368 as amended, say aye. Aye. And all opposed, say nay. No. It appears we have... Let's have the ayes raise hands. We have 2. That means 5 in opposition, so the motion is defeated. Is that correct? So now we're back to the original motion of Representative Ivory to send the bill to rules and recommendation for interim study. Is that, you want to stay with that motion?
Consideration, yeah.
And sponsor, what would be your response to that?
Well, certainly I think that's preferable, and I appreciate the motion. I think that's preferable to just sending it back to rules. I think it'd be helpful, I think, to look at it some more, and I appreciate the recommendation to send it to interim.
And summation from the maker of the motion?
I'll waive.
Motion is to send House Bill 368 as amended to rules with the possibility of interim study. All in favor say aye. Aye. Any opposed? That carries unanimously. Thank you, Representative King.
Thank you.
Non-debatable motion to adjourn. All in favor say aye. We are adjourned. Thank you. Committee members, I appreciate your faithfulness and indulgence.